Good afternoon, everybody. We're just going to wait for folks to join and we'll be starting shortly. We're just going to go ahead and give it a couple more minutes. We have some folks still joining us this morning, or this afternoon, excuse me. So please hang tight. All right. In the interest of time, we're going to go ahead and get started this afternoon. First, I want to welcome everybody and thank you for joining today's webinar. My name is Adonia Simpson. I direct policy and pro bono at the American Bar Association's Commission on Immigration. As many of you may know, in December, Operation Allies Welcome reported that approximately 83,000 Afghans have been resettled, most of whom are individuals who have entered via humanitarian parole. Some estimates state that approximately 60% of the resettled Afghans are not eligible for SIV or special immigrant visas, which makes the context and information from today's webinar so incredibly important. The American Bar Association Commission on Immigration has formally partnered with HIAS on a project to develop both pro se and pro bono materials. And this is the first in a series of webinars. Today's webinar is a general overview of Afghan asylum. We will be taking deeper dives and sharing additional information in future webinars. We will post the links to register for those webinars towards the end of the webinar today. And we encourage you to share that information with others. We encourage you to get involved. We will also give you information on how to actually volunteer and assist Afghans who will be seeking asylum in the coming months and years. Additionally, I would like to extend a huge thank you to Skadden, who is providing CLE credits to the live attendees of today's training. The CLE credits are available for Illinois, New York, Texas, and California. Please stay tuned. We will be announcing the CLE code towards the end of the presentation. You will need this code to be able to complete the CLE form, which will be circulating to attendees via email following today's webinar. For housekeeping, we can't do a webinar without covering the housekeeping. Please make sure that you use the Q&A function for any questions that you may have. Do not use the chat, but we will be responding. Both members of the Commission on Immigration and HIAS will be responding to your questions in the chat. Many of the questions may be more appropriately addressed at some of our deeper dive 102 and 101 webinars that are coming up in the future. Please stay tuned to both of the Commission on Immigration and HIAS's social media and websites for additional opportunities. Since we've covered housekeeping, I want to go ahead and introduce our fantastic speaker for today, Dina Sharuk. She is on contract with the ABA as a senior legal advisor to the Commission on Immigration. Phenomenal presenter. I'm extremely excited to hear her talk today. She has taught asylum law and immigration law at Georgetown University Law Center and the University of Virginia School of Law. She's practiced in both pro bono, legal services, and private setting for 9 years. So we're really benefiting from her expertise today. So again, thank you all for joining. And Dina, I want to pass it over to you.
Thank you so much, Adonia. That's very kind. And thank you all for attending. It's great that there's such an interest in this subject matter. Adonia has highlighted the need. So let's do a little bit of discussion of the roadmap and then let's hop into it. So today we're going to talk, like Adonia mentioned, this is a very broad overview. We're going to give a quick definition of asylum and talk a little bit about the benefits of asylum. So if we're going to pursue it, why do we want it? And then we're going to talk a little bit about who's eligible for asylum. And we'll talk about the affirmative applications for Afghan parolees. This talk is really focused today on those who've been paroled into the United States, Afghans who've been paroled into the United States, and who qualify for asylum. And then finally, we'll end on some of the future presentations and resources and give some opportunity for question and answer. Let's jump into it then. All right, so for asylum, we'll move to the next slide if we can. So asylum really is a form of protection that we here in the United States and in other countries as well, offer refuge to individuals who are fleeing persecution on account of certain protected grounds. We'll get into those protective grounds shortly and a little bit more in depth. We can go on to the next slide. So why would somebody want asylum? Somebody who's entering the U.S. as with humanitarian parole, an Afghan who enters with humanitarian parole, they have a limited and temporary status here in the United States, and it ends generally after 2 years. So what happens to them after those 2 years? Asylum allows somebody to stay in the United States. And it can bestow a derivative status on the spouse and unmarried children under the age of 21. So if you qualify for asylum, your spouse and your children get the benefits of that asylum as well. It is a pathway to citizenship. So after a year of holding asylum, you can apply for legal permanent residence status, or what we colloquially refer to as the green card. And years after that, you can apply for citizenship. There's also permission to work. Now, a lot of people, the folks who entered on humanitarian parole, many of them were issued employment authorization for the time that they're here in the United States, as well as a social security card. But that employment authorization will run out after those 2 years. And asylum also allows somebody to work here in the United States. And finally, when you get asylum, you have access to certain forms of government assistance, financial, medical, access to English language courses, and employment training and placement. Some of these benefits are available for a limited period after receiving asylum, and some are available in various forms after. After getting your green card or legal permanent residence and even citizenship. So now we have a little bit of an idea of why we may want this for our clients. Let's talk a little bit about the eligibility for asylum. So the eligibility for asylum is rooted in the Immigration and Nationality Act, the INA, and truly what it means is somebody who has arrived in the United States who meets the definition of a refugee. Now, we're talking about eligibility today. Just because somebody is eligible for asylum does not mean that they automatically get asylum. We'll talk more about this shortly, but asylum is a discretionary benefit. We'll talk a bit about what can push the scales in a client's favor. There are also bars to asylum, so somebody may meet the eligibility requirements, but then be barred from asylum for previous behavior or actions that they take now. So as we mentioned, somebody who is eligible for asylum is here in the United States and meets the definition of a refugee. And somebody who meets the definition of a refugee is somebody who is unable or unwilling to return to their home country because of a well-founded fear of persecution on account of their race, religion, nationality, membership in a particular social group, or political opinion. There's a lot to unpack there. If we go to the next slide, it's a little bit more digestible looking at it this way, as looking specifically at the elements of asylum. Somebody who's here in the United States. So you can't apply for asylum while you're still abroad. But when talking about folks who have humanitarian parole, they've made it here to the United States at this point. So we can check that little box off. The next is somebody who's unable or unwilling to return to home country. When we talk about somebody who's unable to return to home country, it's often because they've been stripped of their citizenship or their access to their home country. We're not really going to see that much in the Afghan context. We're going to see somebody who is unwilling to return to home country, and for good reason. Somebody who simply does not want to go home for our next bullet, which is the well-founded fear of persecution or past persecution. And we're going to spend a little bit more time talking about this, but this is our standard of proof. You don't have to prove that it's more likely than not that they'll be persecuted if they go back to home country, but you do have to prove that they have that well-founded fear. The next bullet is the on account of, or the nexus piece. This is also referred to as our causation. It's not enough to have that fear of persecution. That persecution would have to be on account of, and then we move to our next bullet, one of those 5 protected grounds: race, nationality, religion, political opinion, or social group. As we mentioned a little earlier, it's the grant of asylum is discretionary, and somebody who would get asylum would have not to be subject to the bars to asylum. So with that, let's move on to persecution. You'll all be delighted to know that persecution doesn't have a solid, concrete definition. Generally, persecution involves serious harm or a threat of serious harm or even death. Some acts may constitute persecution depending on the severity, the frequency, and the cumulative effects of those acts. So maybe one instance or one interaction alone would not rise to the level of persecution, but you can take a totality of circumstances or lived experiences of your client and bring them together to make an argument that in the aggregate, they constitute persecution. And the decision of whether or not certain past experiences actually constitute persecution is decided on a case-by-case basis. As a practice tip, it's a really good idea to just look for cases that are analogous in terms of the harm suffered by the applicant. Cases from the Board of Immigration Appeals or in your circuit or even the Supreme Court will shed light on how persecution is interpreted where you are. So the circuits and the BIA have had disputes about what physical harm, for example, is sufficient to amount to persecution. But some examples that we have seen on the ground are perpetual surveillance, pressure to be an informant, torture, sexual assault, death threats, and it bears repeating, torture. Something important to note is that a lot of times when people think about who the persecutor is in an asylum context, they think that the persecutor must be the government, must be the state. But that's not the reality. The persecutor can be, of course, the government, but it can also be somebody or a group of people that the government cannot or will not control. A lot of the folks that you'll be meeting who are seeking asylum in the Afghan context are fleeing the Taliban, who've assumed the role of government. But one need not prove that they are the government to prove that they are a persecutor and that person is not safe in home country. What is important when talking about your persecutor is this idea that there is no safe place in home country for the applicant to be and to live. And you'll want to collect evidence, such as country condition reports, that show that the Taliban have gained control of the entirety of the country or have access or could find your client anywhere in Afghanistan. So let's move on to well-founded fear. This is our standard, as we mentioned, and it doesn't seem very clear to us what is a well-founded fear. What makes somebody's fear well-founded? Well, there's a subjective element to it and an objective element. And the subjective element is a bit more straightforward. It's just showing that your applicant, your client, is genuinely afraid to return to Afghanistan. And that can be demonstrated, with their own words, with their own behavior, their actions. In the case of many folks who entered with humanitarian parole, they fled to the airport and hopped a flight and have remained on bases before getting here to the United States, and that behavior is also demonstrative of a subjective fear. Something to consider also is having the consideration and the conversation with your client that that they should not feel inhibited in terms of demonstrating or discussing that fear during an interview. In some cultures, showing fear is tabooed. So you'll want to talk to your client about this element. You'll want to talk to your client about all the elements, but you'll want to talk to your client about this one and how it is important to discuss that fear, in discussing their case. The next bit of well-founded fear is this objective standard, and here it's that somebody, a reasonable person in his or her circumstance, would fear persecution. And like I said earlier, it's not that it's more likely than not that they'll be persecuted in home country. Even a 10% chance that they would be persecuted is enough for a reasonable person in that circumstance to fear returning home. If there's a 1 in 10 chance that I'm going to be killed by returning to my home, I might think twice about wanting to return home. In the case matter of Mohrabi, the BIA comes up with a test, and it's a little redundant, but the test for a well-founded fear is that the applicant possesses a characteristic or opinion that the persecutor wants to repress. So let's work with an example. An individual, say, who is Shia, might fear persecution at the hands of the Taliban. If that person possesses the characteristic of being Shia, the persecutor, the Taliban, may want to repress that. And then the persecutor, one would have to show that the persecutor, the Taliban in this case, was aware or likely to become aware of the applicant's religion in this case. That might be that they may have an identity card that lists their religion. They may have been a outspoken member of their congregation. The next bullet is that the persecutor seeks to repress. Oh, we'll go. Yeah, thanks. The persecutor seeks to repress that opinion or characteristic in the applicant, and finally, that the persecutor has the capacity to persecute the applicant. Now, the evidence to prove some of these points may very well lie in country condition reports or human rights reports that detail the Taliban's policies with regards to certain groups. You may also have to rely on news stories, and we'll talk briefly about evidence a bit later. Finally, there's this concept of the pattern and practice claim. Some folks will have experienced past persecution. Some folks will just know that people who are similarly situated in home country are being persecuted, and thus a return to home country would put a target on their backs. And that's really a type of case. Those pattern and practice claims is really an instance in which you would really want to seek out those country condition reports, or even select statements from experts or folks who are similarly situated. We can move to the next slide now. There is no better type of evidence of a well-founded fear than actual experiences of past persecution. In fact, when you present that somebody has already suffered persecution in home country, you've created this rebuttable presumption that they have that well-founded fear of persecution. Now, we're not in court, so the Department of Homeland Security is not opposing counsel in this scenario. We're talking about affirmative applications for asylum generally, when we're talking about the Afghan parolees. But the Department of Homeland Security is adjudicating these cases, and they will have an interest in exploring whether or not any changes in circumstances have happened in Afghanistan since their departure that would show, or since their persecution, that would show that persecution is unlikely to happen again in the future, or even that simple relocation internally within Afghanistan would be enough to evade any kind of future persecution. When we're talking, as in many of these cases, about the Taliban, the situation in Afghanistan has really deteriorated further, and the Taliban has become more powerful throughout the country. So you'd want to collect country condition reports that prove that point to protect your client's claim. There is a presumption that when dealing with government persecutors, there really is no safe internal relocation. And any internal relocation would have to be reasonable. It's not an expectation that somebody, build a bomb shelter and live underground to be, and then they've internally relocated. It has to be something that's reasonable to them, given their access to resources and experiences in home country. We can move to the next slide now. So now we move on to Nexus, which is a very, very important element to prove, and one that can be a little bit more complex. This is our causation piece. It's not enough, as we said, to simply fear that persecution. That persecution would have to be on the grounds of membership in one of those 5 protected grounds. So we're going to talk a little bit more about those grounds shortly. It's in some situations you have a persecutor who makes very clear who they were persecuting and why. And in some cases, it's a bit more murky. It might be that I suspect that I have a government persecutor who's persecuting me both for my outspoken feminist ideals, and also because I happen to own a very lucrative piece of land. That's when we think about the mixed motives of our persecutor. In that case, you would want to show that at least one central reason for the persecution was one of those 5 protected grounds. And that idea of what at least one central reason really is a demonstration that it's more than incidental or tangential, superficial or subordinate for the feared persecution. And that's to say that in that instance, my outspoken feminist ideals would perhaps be would be a strong enough reason, a standalone reason for me to be persecuted by this persecutor. The last bullet discusses kind of watching out for civil war concerns, and that's kind of what I refer to as the things are rough all over pony boy argument. The department sometimes will consider that if a country is in civil war or war torn or is struggling through famine, as Afghanistan is right now, that somebody may just be collateral damage to that civil war, as opposed to having that well-founded fear of persecution. But if you are presenting a strong case for nexus, then a civil war or a famine is not, is largely irrelevant to the fear that your client, has and their claim for asylum. So you'll want to, you'll be able to avoid those kinds of concerns with a strong argument for nexus. So let's move on now to talk about those protected grounds. Here we have race, religion, and nationality, and these are some of the more straightforward elements of asylum. Race, being what it is. If somebody's being persecuted on the grounds of their race, then you very well have a case for asylum. The next is religion, and examples in the Afghan context could be somebody who's Shia, Christians, Baha'i, Ismaili. So sects of Islam, minority sects of Islam are seeing a great deal of persecution on the ground. And those individuals and those who are similarly situated are able to bring their asylum claim. The next is nationality, and here there's a little bit of room for creativity because it's not just one's national origin. Ethnic minorities and tribes can also fall under this nationality protected ground. And that's really important in Afghanistan because you have examples of tribes who are being persecuted, such as the Hazara. Now, some of these groups can be intertwined, and that's okay when you have protected grounds that are intertwined. For example, a lot of folks, but not everyone, who's Hazara are also Shia. And both of those groups, there are reports of both of those groups being persecuted in Afghanistan. So you can tackle it in a couple of ways. You can bring claims for both religion and nationality. That's fine. It's okay to have multiple theories of your case. You can say it's because somebody is both Shia and Hazara. You can also make alternative arguments. This client is being persecuted because they're Shia. In the alternative, they're being persecuted on the basis of being Hazara. So one shouldn't be super concerned about bringing multiple theories for their case. You just don't want to bring so many that you're diluting your arguments here. When you have intertwined protected grounds, it's quite common to bring those multiple theories. Let's move on to some of the more complicated protected grounds. The next is political opinion. So when we talk about a political opinion, we don't have to necessarily, though it's great to have a client who is kind of like the card carrying opposition member who wears the t-shirt and protests in the street. That is great, and one could use that example as or that client for a claim for political asylum, but one need not be kind of that classic dissident to qualify for asylum under the political opinion protected ground. There are circuit splits on the definition of a political opinion, so you'll want to research the definition in your circuit. But political opinions, as we said, don't have to be that classic dissident. They may not be a member of a political party, though they may be. Somebody who holds a particular political opinion, such as a woman who seeks access for education for girls, has demonstrated a political opinion. Also, I need not identify as a feminist to demonstrate perhaps feminist ideals or a feminist political opinion with certain behavior or certain actions. So what's really important here is that when you're working with a client who may have a political opinion claim, that you really get to the nitty-gritty of their experiences in home country, and not just why they think they're being persecuted, but also taking a look at some of the kind of causes and effects. When a client takes action X, then they get persecution Y. And that can be used both for Nexus, but also to kind of get an understanding of why your client is being persecuted, which of those those 5 protected grounds. So as we mentioned, that could be somebody who's in an opposition party, but somebody also who could have a very specific political opinion. There is a circuit split on the concept of neutrality. So somebody who doesn't have a political opinion and is being persecuted because of that, you're either with us or you're against us kind of mentalities. So you'll want to look into your own circuit's case law to know whether or not your client would have a claim in that case. Also, I just want to talk briefly about the theory of an imputed political opinion. And this is the idea where you may not actually hold a political opinion, but one is imputed to you. There's a belief perhaps that I held a very pro-American stance, but that might not be the reality. But nonetheless, I'm being persecuted because of that perceived political opinion. That's a ground for claiming asylum. That is an imputed political opinion case. And imputation can be used in the other protected grounds, though we don't see it as much, and there probably is less case law on it. But we definitely see that more often than not in the political opinion context. Let's move to the next one, and perhaps my least favorite of well, it's not my least favorite. It's just perhaps one of the murkiest parts of the protected grounds, and that's the social group. So what's a social group? No, it is not your clique. It's kind of a catch-all of asylum groups. And as I said, it tends to be a bit more complicated. When you're talking about a social group, you want to prove that this group of individuals, this collection of individuals to which your client is a member, has first and foremost an immutable characteristic. And that's something that is either inherent to them, something that they cannot or should not be expected to change about themselves. For example, sexual orientation or gender identity. That would be an immutable characteristic. The next is this idea of social distinction, also referred to as social visibility. And it's that this group is identified and recognized as a collection of people in that community. So for example, an immutable characteristic I may have is that I have brown eyes. But is that really a socially distinct group? Are brown-eyed folks in my community seen as a group and treated as a a group for which persecution is welcome. That would be a harder argument to make, but it depends on the context. So you'd want to argue that the social group to which your client belongs actually is socially distinct, is distinguished in that society and identifiable. And finally, you have the concept of particularity. So the bounds of that particular social group have to be identifiable, they have to be rigid, they can't be amorphous. I can't be in the social group tomorrow and not the day after that. An example would be wealthy Afghans would not be a very well-defined group. It's not clear what makes somebody wealthy. Somebody can also not be wealthy the day after. When crafting, all things equal, if a social group has already been tried and true in case law, it's a great idea if your client actually belongs to that social group and is being persecuted because of it, or fears persecution because of it, that you go with that tried and true social group. But that's not to say that you yourself cannot, devise and present the social group, a new social group, one that hasn't actually been rooted in any kind of precedent. So as I mentioned a little earlier, there are some examples of social groups that are a bit tried and true: sexual orientation and gender identity. Family groups, so being a member of a family, if you are especially from a member of a prominent and visible family, but also one where, say, that family may be, you may have claims that are intertwined with a political opinion case. So if my father was an informant for the Americans, and I'm now fearful of persecution because I'm his daughter, then I may have a claim for asylum, not just as an imputed political opinion, but also because I'm a member of my family. And I could just show that similarly situated members of my family were also in danger of persecution, if not actually persecuted. Gender and sex tend to be a bit difficult when we're talking about cisgendered folks. As a standalone claim, Afghan women could be successful in some environments, but not in all. And so it's a little risky to present a case that's just Afghan women, say. And that's because there's this, I think, ill-advised concern about opening the floodgates, and then now all women from Afghanistan, this idea being that all women from Afghanistan would qualify for asylum. That wouldn't be the case, even if this was a recognized social group. But because there is resistance to simply, a gender-based, a solely gender-based social group, oftentimes when you're creating a social group that involves gender or sex, you add another attribute that is, a reality for your client, but also it's great for that other attribute to have some root in other protected grounds. For example, Hazara Afghan women, or Afghan women who seek to educate young girls, for example. So it's a murky area of asylum law and the protected grounds specifically, but that doesn't mean it can't be done, and that doesn't mean you shouldn't explore it, especially if the reality on the ground is that that's why your client is fearing persecution in home country. Let's move on to the next slide. Yep. So we're going to talk a little bit now about discretion. And as I said, just because you qualify for asylum doesn't mean you will get asylum. The adjudicator is going to consider a totality of one's circumstances in deciding whether somebody is deserving. And every case is going to have some negative factors and some positive factors. Some examples of what those factors might be would be tender age and health. Somebody is in failing health, it would be there would be an argument there for keeping them here in the United States, especially if they qualify for asylum. If somebody has family members who are in status in the United States, that's a point in somebody's favor. If there are humanitarian concerns regarding return, which I think one could quite easily make that argument in the Afghan context. That's a point in your client's favor. Their manner of entry into the United States. Historically, some adjudicators have not looked favorably upon somebody who has entered the United States without permission. That's not really a concern when we're talking about Afghans with humanitarian parole. They have entered the United States with permission and are permitted to be in the United States. And a lot of the focus when we talk about negative discretionary factors really focus on regard for criminal and immigration laws. And just because your client has a negative factor doesn't mean that you should throw in the towel. You'll want to mitigate those negative factors with a host of positive ones. Some people like to collect character witness statements and submit them on behalf of their client to mitigate some of any kind of negative factors. Let's move on to some of the bars of asylum. So there are a few bars to asylum, and I'm not going to get too detailed here because we really will take a deep dive on this in our future presentation on some of the bars to asylum. But we are going to touch upon them quickly so that you are able to kind of spot some of those red flags. The first is firm resettlement, and that's the idea that somebody has access to a legal status in another country. So if I'm, Afghan and French, it's going to be much harder for me to claim asylum in the United States unless I can demonstrate that I'm being persecuted in both Afghanistan and France. And the idea of somebody who has passed through another country or even spent a little time there, the idea here is not really about the duration of their time in any other country so much as their quality of the relationship between that individual and the country in which they either passed through or spent a period of time. And the second is this idea of a safe third country, and those safe third countries are pursuant to a treaty. Right now, there's only really one safe third country. It's considered Canada. We have a treaty with Canada that indicates that if somebody is an asylum seeker and they get to Canada first, they need to pursue asylum in Canada. They can't use Canada as their route to the United States. The next is the 1-year bar, and traditionally, somebody who applies for asylum needs to file their application within 1 year of entry into the United States. When it comes to the Afghan context, and specifically with those with humanitarian parole, there's definitely been some talk in the background and an expectation that the government is going to extend that 1-year bar to a 2-year bar, the length of one's status in humanitarian parole. But because that hasn't, and though we have an expectation of some advisories coming out from the government and from other immigrant advocacy organizations coming out and saying that you can wait for 2 years to apply, I would still advise that somebody apply within that 1 year until we have anything concrete coming from USCIS or the Department of Homeland Security on this subject. There are exceptions to the 1-year bar, including extraordinary circumstances, and that could be somebody's cognitive incapacity, youth. If somebody's under the age of 18, there's a legal incapacity there, and also if there's really severe mental health concerns as well. The idea then is just to apply for asylum as quickly as one can. But all things equal, if you can apply for asylum within that 1 year of entry for your client, it's really advisable to do so. Another bar to asylum is the persecutor bar. So if your client has ever engaged in any kind of behavior that can be considered as persecution, then they would be barred from asylum in the United States. And something important here to consider is whether, even if they were persecuting somebody under duress, so if they were being forced to persecute somebody, that may also still be a bar to asylum, and something that one would want to explore with their client, and certainly attend our presentation, our deeper dive on the bars to asylum. And similarly, and perhaps the area that we have seen the most concern from the department are the terrorism bars. And those are also referred to as the TRIG bars, the terrorism inadmissibility grounds. So we've seen on the ground a lot of interviews in which this point was belabored. Any and all interactions with the Taliban, any and all support, even if de minimis, even if really quite small for the Taliban, even if under duress, has been explored in these interviews. And if you have these concerns, as we all would, then we should certainly attend that future presentation on the TRIG bar. Any kind of criminal behavior should be explored to understand if there are any kind of bars for asylum. Particularly serious crimes are often are defined as aggravated felonies, and what makes an aggravated felony is a very complicated and rich area of immigration law. So again, I can't belabor this point enough. If you have concerns about the bars to asylum for future clients, as we all should, then it behooves us to attend that presentation. And finally, on any kind of crime that concerns about crime, one need not be convicted of a crime for it to be a bar to asylum. So exploring all of those details with your clients at the intake phase is really quite important. Let's move on to our next bit. So let's talk a little bit now about how to apply affirmatively for asylum for our clients. So you would apply for asylum if you're in the affirmative context for somebody who is in status here in the United States and is not in removal proceedings, and that's going to be the majority of folks with humanitarian parole. You would apply via the asylum office in the jurisdiction where the applicant lives, and you would apply by mail. The information of where you should apply and the form and the instructions for the form are all available at the uscis.gov website. You have a link there in the PowerPoint. The form is called the I-589 application for asylum. That's I think it's 12-page form that you'll be using to, filling out with your client to present. You'll want to read the instructions for the form quite carefully. You'll want to be sure to fill in all the boxes that you can on the form. There were instances in which blank boxes on the form would yield a rejection of the application. We're not seeing that as much now following some litigation, but it is definitely advisable to fill in every box that one can on the I-589 form. If you're representing a client who is filing for asylum, you would also file a G-28 notice of entry of appearance, and it's a pretty straightforward short form describing your relationship to your client. And that's also available at uscis.gov. No, that's all right. We can go to the next slide. Thanks. So what will we see in a typical application for asylum? The first is we'll see a cover letter, and some people treat cover letters differently. Some people use the cover letter as an opportunity to give a short statement about the case, and there should generally be a statement about the case in one's cover letter. And some people treat the cover letter as a full-length brief, and that's a strategic decision that you may make. Asylum officers vary in how much they're willing to, or how much opportunity they have to read in the entire application and submissions. So some people are, make the decision to go for a shorter cover letter, and some put forth a robust legal argument there in the cover letter. You'll also include, as we mentioned, that I-589 form, and if you are representing your client, that G-28 form as well. And when you file a G-28 form, it's notable because you'll receive the correspondence from the asylum office at where you are. So if you would like to be part of the correspondence and know and receive kind of the notices in relation to this case, then you'll definitely want to submit that G-28. And of course, when you submit an application for asylum, you'll want to include as much evidence as possible. Some folks might send a bare bones application and supplement it later, but because this is Afghan cases are being scheduled within 45 days of the submission, you'll get a notice for the scheduled appointment within 45 days of the submission and are being adjudicated within 150 days of that submission. Some people may send a bare bones application just to meet that 1 year deadline and then later supplement. And some may send the entire submission from the beginning because there may be less time between your submission and receiving that notice date. And when you have the interview scheduled, you'll want to make sure that any and all evidence is submitted 2 weeks in advance and received by the asylum office 2 weeks in advance. Some examples of evidence include declarations, official documents, identity documents are required, proof of status, country condition reports, medical reports. So if somebody has been harmed physically, medical reports can be used as evidence to demonstrate some of that physical harm. Psychological evaluations can also be used to demonstrate the effects of any kind of harm, which would be proof of some of that harm, and also proof of well-founded fear. Photographs relevant to the case, news stories. And I think news stories here in the Afghan context are really quite relevant because a lot of human rights organizations are still collecting evidence as to the Taliban's current behavior. For example, the kind of gold standard of country condition reports is the US human rights reports that are issued each year for different countries. And the current report was released before the Taliban came to power. So that resource isn't necessarily available. Definitely keep checking to see if the Department of State has released a newer report for Afghanistan that encompasses the Taliban's now rise to power. But there are some human rights groups that may have their own reports out, and there are also a fair amount of news stories reporting on what's happening on the ground in Afghanistan. Text messages and audio recordings might be great evidence in your case, especially if somebody was receiving threats by text messages. Declarations, mentioned at the beginning, are some of the best forms of evidence in these cases, especially your client's statement. Your client's statement should really note their experiences. Those declarations are an opportunity for the adjudicator to learn about the claim, to receive that statement as evidence, and perhaps the strongest bit of evidence, to bolster your client's credibility. So being able to be interviewed and to discuss the same content that's in that declaration will really bolster your client's credibility, so long as they're consistent. And really, I think that when presenting those declarations, it's an opportunity to tug at the heartstrings of the reader. I mean, this is your opportunity to present your client and to give the adjudicator an opportunity to learn about what they've suffered in home country and what they fear. So certainly don't hold back in those declarations. Something really important to note about for evidence is that evidence needs to be submitted in English. You can submit a document that is in another language, but you would want to have it translated to English and accompanied the copy of the original statement. And all translations need to be certified translations. That doesn't mean that the person doing the translation needs to be a certified translator. It just means that they would need to certify that they have the ability to translate between the language in which they're translating from to English. If you have a copy of that PowerPoint, you'll receive a copy of this PowerPoint. You'll see a sample certified translation link in the notes on this slide. Really important, do not send any originals to the asylum office. That's really important because those originals become part of the record. They can also disappear. So you wouldn't want to send your client's passport or their identity document to the asylum office. You would want to bring those original documents with you to the interview so that they can be inspected. But you certainly wouldn't want to lose them in the off chance that your client, in the chance that your client is not successful in their case and maybe later is pursuing an asylum claim before a court, then they would still want that evidence. So really don't risk it. Don't send those originals. For submission of the application, just review those instructions quite carefully, because they'll have details as to where you should submit the application. And just as a tip, any way that you mail, whether via USPS or FedEx, you will want to get tracking on that submission so that you have proof that it has arrived. Let's move to the next slide. So what can we expect after that submission? Usually within a few weeks of submitting your that application, you'll receive a notice, an ASC notice called the Biometrics Appointment. And that's an appointment for your client and any derivatives to go and get their picture taken and fingerprinted. That information is collected by the government to do a background check. So not much should happen at that appointment other than getting their picture taken and their fingerprints and collecting biometrics information. They shouldn't be talking about their claims. They shouldn't be asked about their claims. And oftentimes clients go without an attorney to those biometrics appointments, unless there's reason or concerns that an attorney would want to accompany them. You'd also receive the appointment notice soon after, and it will list the date and time. Both the biometrics appointment and the interview theoretically can be rescheduled. It can be a little difficult getting hold of somebody to reschedule them. The information as to how to reschedule those interviews or those appointments is listed on the notices. But we have had reports of folks on the ground being at the asylum offices being resistant to rescheduling because of statutory requirements for completing the interview and adjudication within a certain shorter schedule. And then you'll have the interview. Then we can hit that next. Okay, so let's talk really briefly about future webinars. As Adonia mentioned, this is part of a webinar series, and we're really quite excited about it. It's a really exciting subject matter. We have three upcoming webinars. First is a webinar on cultural humility and working with Afghan clients. I think we can turn to the next slide. Cultural humility and working with Afghan clients. And that's really important, not just for the sake of fostering a good relationship with your client and being respectful of your client, though I will say that really should be a priority, but also because that's the way that you can cultivate a relationship where you will collect more information and be able to present the strongest case for your client. So really a really important webinar to attend. And we have certainly some great speakers in this and in other presentations. And then we're expecting that one on February 9th from 3 to 4 Eastern Standard Time. The following one, Asylum 201, that's a really important one for folks to attend. The bars to asylum and common issues in asylum applications. We're expecting that in late February, so stay tuned for that webinar. And then finally, the Asylum 202 webinar, Preparing for the Asylum Interview. That's scheduled for Tuesday, March 15, 2022, from 3 to 4:30 p.m. Eastern Standard Time. And you can sign up and learn more about this and other presentations on the ABA's website, but also following us on social media as well. And I'm sure that HIAS is making this content available as well. Finally, later this week, we expect our pro bono guide for Afghan asylum. Our partnership between ABA and HIAS has cultivated a great pro bono guide for those of us representing Afghan asylum seekers. And you should see that released later, I believe later this week. I believe this is an opportunity now to.
Well, before we jump into questions, there was one more webinar I did want to share. The ABA International Law section is actually having a webinar tomorrow, Thursday, January 13th from 12 to 1 Eastern, entitled Afghan Immigration, What You Still Need to Know. I've shared it in the chat. Also the links for the other upcoming webinars that have been scheduled. Right now, I do want to take this opportunity to announce the CLE code. The CLE code is 766 ASY. Again, 766 ASY. And we will be circulating the CLE form to all attendees after this. Also, there have been some questions. We will be also sharing the PowerPoint presentation. I want to give a huge thank you to our colleagues at HIAS who have been diligently answering the questions in the Q&A. For folks, if you haven't been watching the Q&A, there have been some amazing questions and responses from Sarah and Rachel at HIAS. We will be downloading that and sharing that along with the PowerPoint. So please stay tuned for that. And in these last 4 minutes, we do want to open it up for questions. So if you have not had your question addressed in the Q&A, please feel free to raise your hand. And Bridget, will you be able to take people off mute for questions? And while we're waiting for that to happen, one more thing I wanted to announce is I did share the link in the chat to actually get involved. Dina has shared this phenomenal information with you, this general overview of asylum and the asylum process. But if you want to take that next step and potentially take a case that is being vetted by HIAS of its affiliates and receive mentorship and office hour support, I did provide the link to sign up. Rachel, I don't know if you want to pop it in the chat again, because I think it got a little bit buried.
Oh. I just did. You read your mind, Adonia.
So in these last few minutes, if you do have any questions, please feel free to raise your hand. It looks like we have Leah Wilson. Bridget, would we be able to bring her off of mute to ask her question?
Adonia, before we do that, I'm sorry to interrupt. Can we read the CLE code out one more time? I think a few people missed it.
Of course. Again, the CLE code is 766 ASY. Again, 766 ASY. Bridget, are you able to take folks off of mute who've raised their hands? All right. It looks like as hands raised right now, we have Mark Davis.
Ignore me, Adonia.
All right, no worries. Any other questions? Well, again, we'll be sharing the responses from the Q&A. Again, thank you, Rachel and Sarah, for addressing all of these phenomenal questions. And we'll be sharing the PowerPoint with you all. And please stay tuned. Please tune into the deeper dives where we'll be exploring a lot of the questions that you all had today. All right. Okay.
Thanks again, everyone.
Thanks, everybody, for joining us. We look forward to working with you.
Thank you all. Have a great day.